College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Good afternoon, ladies and gentlemen. I welcome you back to the series that we're doing on the topic, Know the Law. This is the third in our 6-week series on this very important subject, and I would like to recognize the Kootenai County Bar Association for their fine cooperation in the 6-week series. Also on this program, as was true of a previous one, we wish to also recognize the cooperation of the Spokane County Bar Association in providing a guest to our program. Today's subject is going to be consumer purchasing. That is an issue that is very important to you, and we are very fortunate to have 4 guests today that will discuss several aspects of that issue. I would like to welcome to our program, first of all, Pete Anderson, who is an attorney in Coeur d'Alene. Next to Mr. Anderson is Michael Flynn, who is Assistant Attorney General for the State of Washington, located in the Spokane office. Our third guest is Charlie Dodson, who is an attorney in Coeur d'Alene. And our fourth guest is Ann Solomon, also an attorney in Coeur d'Alene. I would like to especially recognize Ann for her great cooperation in aiding me in setting up all 6 of the programs with Denny Davis. Thank you, Ann. Our panel today will be regular panelists, Mary Lou Reed and the Assistant Vocational Director at North Idaho College, Bob Brown. We're happy to have them to return to help us, and they've been very cooperative in this series. I will invite Lou Reed to commence the questioning.
Thank you, Tony. I would like to first ask how good a package of consumer protection laws our panel believes that we have in Idaho and Washington. Why don't I direct that question to you, Charlie? Would you tell us first what you think Idaho's situation is?
Really, Mary Lou, it's going to depend on which side of the fence you're on, whether you're the consumer or the other side, the individual selling to the consumer. From the other side, I would say it's a very good package. From the consumer side, it's probably not the best. I think counsel from Washington, who has a much more comprehensive consumer protection law, could answer your question regarding the state of Washington and probably much greater expansion than I can regarding Idaho.
Okay, but then does this mean that you feel that Idaho perhaps needs some laws to be developed to assist the consumer side?
From a personal standpoint, yes. From a professional standpoint, I'm usually on the other side of the fence, no.
Okay, well, Mike, what can you tell us about Washington?
The state of Washington is, I think, the citizens have a right to be very proud of the fact that our Consumer Protection Act is very flexible and very meaningful in terms of actually providing practical relief to the consumer. From the other side of the coin, as Charlie was talking about with regard to the businessman, I think it gives a clear indication to the businesses operating in the state of Washington exactly what it is that they have to be careful of in dealing with the public in the state of Washington. Washington's Consumer Protection Act was adopted by the legislature in 1961. We were one of the very first states to have a comprehensive Consumer Protection Act. And based on that early development in our state, the legal precedent that has developed around that law is fairly extensive. In contrast to my understanding as to what Idaho law is, it's not quite as comprehensive. As far as the Attorney General's office is concerned in the state of Washington, we are very active in enforcement of that statute, as we are mandated by the statute to carry out the directives prohibiting unfair and deceptive trade practices in the state. In contrast, the state of Idaho's Consumer Protection Act does not have that type of active enforcement through their Attorney General's office. And I think that might be a substantial hindrance to the consumers in the state of Idaho. But as far as the state of Washington is concerned, the package is fairly comprehensive, and with the legal precedent that has been developed around that statute, the consumer is fairly well protected.
Thank you. I think that sets the stage.
Bob Brown.
I'd like to talk about repossessions, and I'll address my questions to Pete Anderson for Idaho and then Mike for Washington. Basically 3 questions, and I'll state the 3 questions and ask you to comment on this package deal. What do you do if your property is repossessed? What preventive measures can you take? And can you be liable for money in addition to the property? And Pete, why don't we start off with Idaho?
Thank you, Bob. Bob, there's two types of property that can be repossessed for the average consumer, and the first is real property, the land you have bought or you live on. Oftentimes, that property will be secured by a deed of trust or by a contract. Contracts for sale of real property are real common in Idaho. If your real property is repossessed under a deed of trust, the statute is very clear what happens at the conclusion of the redemption period. That property can be sold. You don't get, if there isn't any money in excess of the amount you owe, you don't get anything back. You could even technically be liable for a deficiency. The deed of trust law is relatively fair, I think. It works out in practice well. Using contracts for sale of real property, frequently those are written by the sellers and usually have terms very favorable to the seller on default. What can happen, what is found in an awful lot of these contracts, is that if you do not make your payments in a timely manner, you lose everything, usually within about a 30-day period. Now, if you've paid a substantial amount for that property and the seller takes it back and you don't get anything back from him, in other words, you've paid half of the total purchase price, you missed one payment and you've lost that property, I would strongly advise you to see a lawyer. The law permits that, but you have some right of restitution. In that respect, I want to mention a preventive measure. If you're going to sign one of these real estate contracts, and if you're willing to commit yourself to $20,000, $30,000, $40,000 in liability over so many years with balloon payments and all sorts of default provisions, I would strongly advise you to see a lawyer before signing that contract, especially if there's some term you don't understand, any kind of legalese. So it's definitely worth the cost. You know, you can see a lawyer for an hour or two. Compare that to the problems you might have on a $20,000, $30,000 contract. Under a deed of trust, you can technically be liable for money in addition to what the property sold for at the auction. Under a contract for sale, usually you will not be liable. It'll be liquidated damages. With respect to personal property, something like a vehicle, which is the most common type of repossession, I think the preventive measures are the most important to stress. Here too, the law is very well worked out. There's a uniform code on the matter. I would say it's fair. It's as fair as the law can be. You know, it doesn't take into account bad times and good times, but maybe the law can't do that. The preventive measures you can take are to attempt to sell the property before you become in default. If you have a vehicle that you know is worth $4,000, you owe $3,000 on it, it'll be a lot better for you if you sell it at $4,000 in a private sale and pay off the bank, or sell it at $3,500 and pay off the bank, than to have them incur the expense of repossessing it, selling it in some kind of forced sale, maybe getting a lower price than they would in a normal market transaction, and possibly even incurring attorney's fees. You very definitely can be liable for a deficiency, and it is not infrequent for banks to sue debtors for that deficiency. If your vehicle has been repossessed, though, chances are good that it was repossessed lawfully. You probably are, just as a guess, knowing nothing else about your case, you probably have not been injured legally. That isn't to say you haven't. Legal Aid in Idaho has a list of attorneys who will give you a free 15 to 30-minute consultation. If there was anything at all irregular about the repossession, or to your mind irregular, I would advise you to call them, get that free consultation, and if there is anything, it can go from there.
How about Washington, Mike?
Basically, the law is the same in Washington as Pete has described it with regard to real property and to personal property. I would, however, note that there are specific statutes in Washington State regarding the repossession of certain property, namely personal property. Washington has adopted the Uniform Commercial Code, which gives the individual who is going to repossess the property certain remedies and certain procedures to follow as to how to do that. A person whose property is being repossessed can demand that that individual who is repossessing the property follow those procedures. But basically, as Pete has described it, that would be the case in Washington also.
I would like to get into another area. We have so much to cover on consumer purchasing. We'll get in as much as possible. Mr. Dotson and Mr. Flynn, you will fill this question. Dealing with home solicitation sales, and that's, I understand, a growing business these days. I really have a three-part question, and then would ask both of you to address those questions. First of all, what special rights does a buyer have after a home solicitation sale has taken place? And two, are there any special requirements in the notice of cancellation? And third, must the seller notify the buyer of the right to cancel a home solicitation sale? And may we start with you, Mr. Dotson?
Well, the answer to question 3 is yes. Now let me go back to follow the questions in their order. Special rights. Home solicitation sale is governed strictly by statute in the state of Idaho under our adoption of the Consumer Credit Code. It can be found in Volume 5B of the Idaho Code, which is available in most public libraries if anyone wants to take a look-see, in Title 28. The home solicitation sale is defined as a consumer credit sale of goods other than farm equipment or services in which the seller or a person acting for him engages in a personal solicitation of the sale at the residence of the buyer.
But it has to be at the residence.
It has to be at the residence. If you're dealing with a business, say a furniture store, and you've been in there several times to talk to them about, gee, I really like that chair, maybe we'd like it, maybe we wouldn't, then they come to your home with the chair in their delivery rig and say, gee, we know you like the chair, we brought it with us, let me put it in your living room, see how you'll like it. That may not be a home solicitation sale because you have had prior contact outside the premises. There are definitely special rights to the buyer in a true home solicitation sale. The buyer has the right, the unqualified statutory right, to cancel the sale within 3 business days or prior to midnight of the 3rd business day subsequent to the sale.
In Idaho.
In Idaho. That's specifically governed by Idaho Code. For instance, the proverbial vacuum cleaner salesman comes to my home Monday morning, and he will not leave until I buy the vacuum cleaner. So I buy the vacuum cleaner. Tuesday afternoon, I get to thinking, gee, we already have a vacuum cleaner. This one really, I don't think it will do all he promised it would do. What do? I send him a notice of cancellation, which is also set forth in the code. Now, you don't have to go to an attorney to have this notice prepared. The code says it can be any form written which indicates to a reasonable person that you don't want the thing which was sold to you. It has to be deposited in the United States mail, as is required by the statute. From a legal aspect, I look at it from a proof problem. That deposit in the mail, unless you've kept a receipt or you have a witness watching you put it in the mail, is going to be a little difficult if you get into litigation on the matter. It would be wise to go a step beyond what the statute requires and send it certified mail to the seller at the address on the paperwork that you have. That would comply with, in fact, it would more than comply with the statutory requirements regarding the notice to the seller. One other thing, a step or two beyond that, the seller has 10 days from the day that notice, apparently from the day that notice is mailed, to retrieve the goods, or you can't retrieve a service, but to retrieve the goods. If he does not do so, the buyer, me who got stuck with a vacuum cleaner, I can hold on to that. Now, I have to keep it in good condition, has to be in the same condition it was when I received it, or substantially the same. I can hold on to that until he brings me back the paperwork noticing it's canceled, or my $50 deposit, or whatever the deposit happened to be, or the promissory note, or the installment contract that I signed. He must bring that back. If he does not do so within, and the statute makes reference to a reasonable time, and the writers of this particular code, which is adopted in the majority of the states, have indicated a reasonable time is 40 days. He doesn't bring it back to me within 40 days. He doesn't come pick up his equipment. Or he does bring my refund back, but he does not pick up the equipment or the thing that I bought, the vacuum cleaner. It's mine. No questions asked.
If he does not notify you when he sells it to you that you have this right, then even in a longer period of time, would you be liable to continue to pay for it if he's not notified you of your right to counsel?
If he's not notified you, then we're going to be shifting a little bit from the Consumer Credit Code into Idaho's adoption of their Consumer Protection Act. That would be an unlawful, or misleading trade practice. It's in violation of the Consumer Credit Code, could be enforced by an action at law. And in all likelihood, if me as the buyer could show that I was not giving any notification that I had this right to rescind, which must be given, spelled out in big capital letters or bold letters, I could literally sue the person who came to sell me this thing. I may even be able to keep the thing, and the other person would have to pay, in all likelihood, my attorney's fees and costs, and have the matter resolved, and may even be enjoined from similar practice.
Mr. Flynn, is there any difference in Washington?
Unfortunately, Washington is one of the few states that has not adopted the Uniform Commercial Credit Code. Therefore, the concept of a home solicitation sale is not applicable in Washington law. What Washington law is basically that when you are dealing with a retail installment transaction, as defined by the statute in Washington, then the buyer does have the similar rights that Mr. Dodson was describing with regard to cancellation of the contract, with regard to notification to the seller's right within 10 days to get the merchandise. But Washington describes their retail installment transaction a little differently than what is described as the home solicitation rule. There is the requirement that the contract actually be entered into away from the seller's normal place of business. So rather than focusing on the buyer's residence, it just must be away from the seller's ordinary place of business. And then the particular transaction itself must fall into a couple of different categories. Basically, without trying to get too complicated on the legal aspects of it, it has to involve some kind of installment payments and a service charge, and combinations of those two. If there is no service charge on the contract for the sale of goods, then the installments, the consumer would have to pay off in more than 3 installments. If there is a service charge involved, then the consumer would have to make at least 1 additional installment payment. With those definitions in mind, the basic rules that Charlie was describing would apply.
Thank you. Lou Reed.
I would like to ask a quick question, which I gather will have very quick answers. If I go to the used car lot and I buy a used car, and this car turns out to be a lemon, what recourse do I have? Any, Pete?
Well, I suppose it would depend on what representations have been made to you and what the used car dealer knew about the vehicle when he sold it to you. I would think if he knew there was something seriously wrong with it, say the transmission was shot, didn't tell you that, sounds actionable in fraud. Certainly if he knew the transmission was bad and said to you, well, we've just got this new rebuilt transmission in here, you'd have an action in fraud or under the Consumer Protection Act.
Would I be likely to have a good case?
I don't think any of us would want to answer that without getting down to detailed facts. It's really difficult to give a good, broad, general answer given some very limited facts. I have a tendency to agree with Pete. More than likely, some form of action is going to be founded in fraud for a misrepresentation. They either told you something that wasn't true or didn't tell you something you knew and you wouldn't have bought it if you'd known.
But basically, there's nothing cut and dried in terms of if you sell a person a bad car.
Well, one thing to remember, Lou, you know, sometimes you are taking the risk when you buy that car. You know, if they say to you as is, certainly if they say to you as is, or if it's the implication, you're going to take the risk. You're going to bear that risk.
That's the old adage, yes. Would you buy a used car from that man? Yeah.
Well, not just from the man, but that car. You know, maybe they don't know. Maybe they don't know. You've got to, you know, you have an opportunity to look at it. You have an opportunity to have someone you know look at it. That's gonna weigh against, you know, these concepts of fraud. Practically, One problem is, you know, the amount of money involved is probably not going to be that large. If it's a lemon, it's probably an old car. It's going to be hard getting a lawyer that's going to be that interested in the case. Again, prevention is
Right. Your advice then is be very, very careful about buying a used car because the legal situation would be long and perhaps iffy.
But there's another point too, and that is buying used anything under the Uniform Commercial Code. There are implied warranties of fitness, and that is when you buy a good from a person in the business of selling goods of that kind, there is an implied warranty that good is fit for the purpose for which you bought it. If you indicate to the seller the purpose you're buying a good for. But if the seller says to you, okay, this is as is, or even if the seller doesn't say anything about the condition of the car, but on the contract there's the wording "add is" in fairly bold type, then the buyer does not have recourse to go after the seller under a warranty provision.
That's helpful to know.
There-
helpful.
there
Bob
is one-
Brown. We must move on.
I'd like to get into the area of credit reporting, and Ann, I'd like to address this to you. Been a lot of publicity and so forth about credit files and what rights do people have to look at their files, and what is a consumer reporting agency and so forth. And I'd also like to have you, in addition to discussing the consumer reporting agency and the report and whether or not you can see the report, address yourself, if you would, to when there's an error in your report, what do you do to correct this? And if there is time, and there may not be, I'd like to, one that I get a lot of questions about from students are when there's a divorce and a woman, the man, let's say, has had the credit in his name, and there's a divorce, and the woman thinks that she has all these charge accounts, or at least has the credit. Would you comment on that
Okay.
at this time?
Let's start at the beginning. First of all, what is a consumer reporting agency? It's an agency or person or any organization who, either for money or not for money, engages in the business of putting together credit information. In Coeur d'Alene, we have a credit reporting agency. That's what most people commonly look to in terms of credit reporting. A credit report can be of two natures, and this is something which I most recently learned. It can be not only a report just involving your credit worthiness, but also a report involving your personality. So in other words, if you have any strange habits or background that a potential employer, for example, ought to know, that employer can ask a credit reporting agency to put together a personality investigation on you. But there are restrictions regarding that, and that is you've got to get notice of that, and then you have the right to have full disclosure of anything reported by that agency and also to whom it was reported. So, but generally the credit reports that we see and that people call about are credit worthiness. In other words, what kind of background do you have in your monthly payments? One of the most common questions that I'm asked, and one of the ones that you've addressed today, is what happens if there's an error in your report? First, let's preface that by saying you have the right at all times to see the information in your credit file. Okay, and I understand from the credit reporting agency here in Coeur d'Alene that they do charge for that. It's some minimal charge. The last time I checked, it was $4. Okay, but you may go see your file, and then if in looking at it you discover that there's an error there, you can demand that error be corrected, and then the reporting agency must immediately reinvestigate in order to check the validity of that particular bit of information. And if in fact they recheck it, they don't have to recheck it if they think that you're some kind of kook or they think the charge is frivolous. But if in rechecking they decide that in fact that error, that the report that they have prepared is correct, then you're entitled to prepare a 100-word statement and have that included in your report and sent to every creditor or potential employer or anyone who asks for that report. And if in fact they don't do that, then they're subject to both civil and criminal charges. So the credit reporting agency is bound by that. And then the final question is what happens if there's a separation or divorce and there are actually two persons who want to claim that credit file? And the answer to that is yes, that same credit history that you have as a married man, you also have the right to have a new file set up in your name as a single man or a single woman after a breakup of marriage.
And there's another area that is certainly important under this topic, and that's the question of interest on loans and things that are borrowed. Could you give us some information? I know we're very short on time, about 4 minutes, on the definition of consumer credit sales, and I'm particularly interested in what is the maximum amount which the seller may charge for a consumer credit sale, and if we have time getting to some other contracts and if there's no agreement on interest, what is allowed.
Okay.
And so forth.
Interest is an area which I think all of us panelists would agree is really complicated in this state, partly because of various statutes which have been passed because of lobbying efforts of creditors and banks and everyone with their own special interest. A consumer credit sale is a sale of goods or services or land by a person who is normally in the business of extending credit. Okay. And although the statutes are really complicated on that, and this is not at all intended to mislead people or to simplify it, but because we have a shortage of time, the amount of interest that can be charged in consumer credit sales can be summarized as follows. If you are borrowing from an agency, for example, like a finance company, okay, and they are authorized by the state of Idaho to lend at high rates of interest, and that means above 18%, then you can be charged 36% on any amount that you borrow of $540 or less. That seems outrageous to me, but that's what the statute is. And you can be charged 21% on the sums of $540 to $1,800 and 15% on anything over $1,800. Now typically what the credit agency does, and this is authorized in the statute, is just charge a straight 18% for a consumer credit sale, and that's got to be distinguished, and that's from a person normally in the business of extending credit, and the goods must be for household or agricultural purposes, and the buyer has got to be a person, not a business.
Does the contract have to clearly state, interest can be very confusing. They can say it's 12%, but is it 12% on the unpaid balance, or is it 12% on the total sum? Do they have to always make that clear to you?
That's got to be spelled out, but the problem is, and is anyone who's read one of those contracts, even if it's spelled out, you can't understand it, because you can't understand not only how they compute it and what time frame they use to compute it, but yes, the creditor must spell out in detail the rate of calculation, the other charges that are going to be made, in other words, insurance charges, and also the exact amount of interest that will be charged. Real quickly, I want to mention a couple other interest rates. There's another provision in the code that sets out other kinds of contracts. If you have a contract in which your real property is used as security, and if your real property is the primary, is one which could be your residence, then the maximum interest is 13%. And that's what people ought to know, because that's a statute that isn't very well known.
I'm so sorry we're out of time. I wish we could deal with this in more detail. It just illustrates how many questions there are that are legal. Thank all four of you very much. You've been extremely informative, and it's been very helpful to us all. Sure. And I thank the panel for outstanding questions. Ladies and gentlemen, our program today has been with a number of attorneys from Coeur d'Alene and Spokane dealing with the question of consumer purchasing. I hope you'll be with us next week at the same time, when we'll continue in the fourth of this series. Please have a good week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.